Good afternoon, welcome, and thank you for joining us for today's webinar on Stuck Between a Rock and a Hard Place, Employer Predicaments in a COVID-19 Environment. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Warden Smith. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both our videos and slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose Side-by-Side mode. The slide text should appear on the left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. We have scheduled time after our speaker presentations to answer any questions you may have live. If you have a question at any time during the webinar, please type it into the Q&A box and we will do our best to address all questions as time allows during the roundtable discussion. Now, I'll turn the mic over to Ken Gray to kick things off.
Good afternoon. My name is Ken Gray, and I'm the practice section leader of the Labor and Employment section at Warden Smith. And 6 months ago, in mid to late March, our world was turned upside down due to COVID-19. And members of our labor and employment team began pulling anywhere from 10 to 16-hour days trying to help businesses survive the pandemic. And without further ado, let me introduce part of our labor and employment team that's going to be speaking today. First, we have Tom Zimatics. Tom is going to talk about the Paycheck Protection Program, and just a little of information about Tom. Immediately when the CARES Act was passed, Tom read every word of the Paycheck Protection Program, or PPP, portion of the CARES Act right after Congress passed it, and he became a leading expert in North Carolina. But not only in North Carolina, lawyers in other firms across the country have consulted Tom about the PPP program, and so you're in for a very informed discussion with Tom. Next up, we have Will Oden. And Will is going to talk about what to do when employees complain to OSHA about COVID-19 concerns. And Will is the only licensed attorney in North Carolina who is also MESH certified. Will is also OSHA 30 trained and has an advanced safety certificate from the National Safety Council. Next up will be Emily Massey. And Emily will address teleworking and how to deal with employees who do not want to return to work. Emily is the person in our team that we looked to when nobody knew what the answer was, and we knew that we had to dig deep and find whatever we could across the country to determine what the best practice was, and she always came through for us. Next up, we have Haley Wells, and Haley will talk about what to do when an employee tests positive. Haley was the person in our team meetings when we were trying to figure out what was going to come down the pipe next. She was the best one at predicting what the DOL would do when they were issuing their new guidance. Next is Grant Osborne. And Grant will talk about changes due to a recent court decision in DOL regulations. And Grant's the guy that would look through the regulations with a fine-tooth comb and pick up nuances that other people missed. And so he was very valuable in that standpoint. And then we have Xavier Lightfoot, and Xavier will talk about unemployment issues. Xavier has become a leading expert in a very short period of time on COVID-related unemployment issues. And I've been doing unemployment for about 27 years. And just Xavier's even taught me some things. So he has done a great job. And finally, we get to Justin Hill. Justin has just joined the firm and our team as of Monday, although he was a summer associate with us for the last 2 summers. Justin will help moderate the pre-submitted questions and also any questions that you submit during this, this presentation. And not only was Justin top 10 in his law school class, but he was also, his moot court team won a national championship. So I must say that Justin, it's an honor to be in the presence of a national champion. With that said, Tom, take it away.
Thank you, Ken. Good afternoon, everyone. Thank you for joining us today. As many of you know, the Paycheck Protection Program has been in existence now for about 6 months. As Ken said, it was created under the CARES Act back in March. And since that time, many of you have experienced it. It's gone through many different phases. It's gone through some changes to the program. And it seems like throughout the summer, the focus has been on different areas of the PPP. I think it's safe to say that we are now in the phase where most borrowers are ready to apply for forgiveness, which is a key aspect to the PPP, or some borrowers are ready, have applied for forgiveness or are ready to apply for forgiveness, but their lender is not ready to accept the application. So the main purpose of my talk today is talk about what you can do right now if you're in that phase of looking to apply for loan forgiveness. So if you're ready to apply for loan forgiveness, that means a couple of things. Under the PPP, you can apply for loan forgiveness as soon as you've spent the loan. Many of you know the term covered period. And if you recall, the covered period is either 8 weeks or 24 weeks, which immediately follow loan disbursement. Now, you have that amount of time to spend the loan, but with the change to the PPP back in June, a lot of borrowers are now electing the 24 weeks, and many find that they could spend the amount of their PPP loan on payroll costs or non-payroll costs well before they reach the end of the 24-week period. So if that's the case, or even if you take all 24 weeks to spend the loan, as soon as you've spent it on eligible payroll costs or eligible non-payroll costs, you can go ahead and apply for loan forgiveness. The absolute deadline to apply for loan forgiveness is 10 months after the end of the covered period. So if you got your loan in April, the end of your covered period, even if you spent all the loan beforehand, will likely take place sometime in October. You must apply for loan forgiveness at least 10 months after that. If you don't, then you have to start making payments on the loan under the terms of the loan. So a lot of you may be asking, well, if I've spent the loan, I'm ready to apply, why can't I apply for forgiveness if I haven't already? And really the answer to that is you must apply for loan forgiveness through the lender who issued the PPP loan. And these lenders are all moving at their own pace. And it's understandable. As you're aware, PPP has changed multiple times throughout the summer. It's changed recently. And so with changing rules, many lenders are not comfortable yet with processing forgiveness applications when the rules underlying the forgiveness calculations may change. Another reason is there's a lot of applications to process. And some lenders are hopeful that there's going to be a change in legislation or change in the program, which would eliminate the need to apply for loan forgiveness for some borrowers. And I'll talk about that briefly here in a moment. But really, applying for loan forgiveness comes down to the relationship you have with your lender and being in contact with them. My best advice for you today, if you've spent the loan and you're ready to apply, but you just have not been able to apply for loan forgiveness yet, would be to stay in touch with your lender, understand their timeline for accepting loan forgiveness applications, and start to get a sense for what they're going to require. Now, the SBA has published their own forgiveness forms, and they've posted it on their website. Most lenders are going to take those forms, adopt them, make some changes that are conducive to their portals or their software applications, and then have their own process for accepting your application. So it would be beneficial to you if you look through some of the SBA forms currently, but then check with your lender to make sure what they'll be looking for specifically. Now, talking about working with your lender, let me talk about a key aspect to loan forgiveness, which is documentation. I'm sure many of you right now are at home with kids, teaching them as they're learning remotely during the school year. And just like we learned, you're probably telling them with their math homework to show their work, right? If you have the answer, the right answer, that's great. But in order to get full credit, you have to show your work. Well, the SBA is requiring lenders and borrowers to do the same thing. You know, if you think about it, forgiveness goes back to the initial purpose of PPP. You know, back in March, many businesses, and some still are, were shut down. And the purpose of PPP was to allow those businesses to have extra funds to apply towards payroll, rent, utilities, mortgage interest. And then you also want to run a check to make sure that they're able to maintain employment levels, not reduce salary and wages for certain employees. And if you're able to meet the purpose of the PPP, then you should be eligible for full forgiveness. So on your forgiveness application, you're going to be providing those answers. You're going to say, I received X amount of the loan, and during my 24-week covered period, I've spent X amount on payroll. Some of you may provide documentation showing that you also spent some of the funds on non-payroll, like rent and utilities. As you do that, you're going to have to supply documentation substantiating those answers. So for payroll, you're going to want to provide internal payroll reports showing that funds were actually allocated to certain employees to pay for their payroll. You're going to want to show tax forms 941 for the period. For non-payroll costs, you're going to want to show receipts. You're going to show the lease agreement that it was in place back in February, which was a requirement to spend the loan on that cost. And then for salary and wages and reductions, you're going to have to show that you didn't slash salary or wage rates for certain employees during the covered period. And then a key aspect to forgiveness, which has been a focus for many, is keeping full-time equivalent FTE employees up during the covered period as compared to a previous period. Well, if you say that you've maintained employment, you're going to have to show tables. You're going to have to show the calculations where you've calculated the number of employees you have and compare it. So keep in mind the documentation requirements. You know, many of you are ready to apply now for forgiveness, but there is a reason, I think, that the SBA is allowing borrowers to apply for forgiveness 10 months after the covered period. It's because it's going to take a little bit to make sure you have the proper documentation for your loan forgiveness application. And you're going to have to work with the lender to make sure that it all meets their requirements as well. So my third point in my discussion today is what to do if loan forgiveness is denied. As I said, the documentation is going to be the responsibility of the borrower. So when you submit your loan forgiveness application to the lender, you're going to provide the documentation. The lender has the obligation to have a good faith review of what you submit. If something is missing, let's say you have the payroll number in your forgiveness application, but you don't have the documentation supporting that, the lender should work with you to get that addressed. Most lenders should not, under the guidance, outright deny loan forgiveness on that basis. That being said, it would be best to have it ready for the lender when you first submit. So the lender has 60 days here to review what you submit to them. The lender is going to go through the documentation. They have certain requirements they have to check off. They have to make sure that documentation is provided, calculations add up, and that you've certified that you're eligible for loan forgiveness. During that 60-day window, that's the time to work with the lender. If there's any deficiency, stay in contact with them. After the 60 days, that's when the lender issues its decision to the SBA. And so the SBA then has 90 days to issue their decision. And if the lender has approved a forgiveness amount, the SBA then has 90 days to confirm or deny that, and then remit the forgiveness amount to the lender for forgiveness. During that 90-day review, or at any time, the SBA may look at a number of things. They could check the math, but they're also going to look for eligibility concerns. Was there an issue in your application originally for the PPP loan that they didn't catch? They're going to look for unauthorized use. Does your documentation actually show that you've spent the loan on eligible payroll costs or eligible non-payroll costs? They're going to be on the lookout for that. If you find yourself in the situation where the lender has accepted your forgiveness application, they issue their decision to the lender, to the SBA, and then the SBA comes back around and says, actually, no, you don't qualify for forgiveness. You weren't eligible for the PPP, or there's unauthorized use, or they find some problem with your PPP application. You have a short window to address that. You have 30 days from the time the SBA issues a decision denying loan forgiveness to make an appeal to the SBA. So if there's a takeaway from today's talk outside of the general forgiveness process, keep in mind that if the SBA denies your loan forgiveness application, which is different from a lender decision, but if the SBA denies your loan forgiveness application, you're going to have to work quickly. That may be months from now, given the fact that lenders and the SBA have multiple months to review your forgiveness application. So keep it in mind. If your loan forgiveness is denied, just know that you have a 30-day window to act on it. And lastly, I want to talk about one of the reasons lenders are currently moving at their own pace with forgiveness applications. I think there's a lot of hope or fear, depending on what you're concerned about, that there's going to be additional changes to PPP. Currently, there's nothing on the table that's immediately going to change the program. It's not to say that it can't happen later this fall or early in 2021. But at this point, if you want to apply for forgiveness, you're going to have to go through the rules that are currently in existence and aren't set to change anytime soon. And that means putting together your documentation, submitting an application to the lender, and then having that wait time between the lender decision and SBA decision to ultimately have forgiveness confirmed or denied. And then keep in mind, if it is denied, you're going to want to act quickly since you have 30 days after the SBA's decision to appeal it. So that's the forgiveness process. I'm sure many of you are anxiously awaiting submitting your forgiveness application or hope to do so soon. So work with your lender. Right now, the best thing that you could do is make sure that you're on the same page with them in terms of what they're looking for in your application and the timing that they're providing for when you can submit it. So with that, I'm going to turn it to my colleague, Will, who's going to talk next. Will?
Hey, thanks, Tom. Good to be seen. Thank y'all for spending your lunch hour with us. And hope that this is helpful. What I want to speak with you today, what I want to speak with you about today are OSHA letters and investigations, and specifically complaints that we have dealt with over the last several months received by the North Carolina Department of Labor Occupational Safety and Health Division. Typically, what you see is a form letter that comes in. It's typically 2 or 3 pages long, very serious looking, and in a very brief description, you read what the employee or employees are alleging that you've done wrong. Primarily, the clients we have helped, and we've probably handled at least a dozen of these in the last several months. And primarily the employees or employers that we've helped with these complaints. Most of the complaints stem from issues that employees are seeing in the way that the employer is handling their sanitization process, whether the employer is requiring the wearing of masks, whether social distancing is being enforced, whether the employer is allowing infected individuals into the workplace, but typically the allegations are very broad. You're going to see something very broad come across your bow. And the instinct sometimes is just to provide a very simple response and denial to the complaint and hope that it goes away. And I'm here to tell you today that's probably the worst thing you could do. So why do I think that you need to provide a detailed, thorough response that addresses not only the allegations, but also generally what you are doing in this pandemic to protect your employees? Well, that's because the letter in the fine print at the top of the letter will refer to the general safety duty clause. And safety duty clause allows OSHA to cite you generally for not providing your employees with a safe and helpful work condition. It also gives employees a toehold to sue you later if they come down with a physical condition that they believe was caused by conditions in your place of employment. So all that to say, it's important to provide a detailed response. It's also important to pick up the phone or have your lawyer pick up the phone and call the individual who wrote you the letter, even though it's a form letter, and let them know that you have received it and you are taking it seriously, and you'll provide a response within the time frame indicated. If you need an extension of time, they're going to be more than willing to grant it. Typically, the deadline is a 7-day deadline. The OSHA administrator down here in Southeast North Carolina, Lafayette Atkinson, is very responsive, as is his counterpart up in Raleigh, and is great to work with. But the reality is you need to provide a very detailed response and as soon as possible. So far, knock on wood, the ultimate result we've been able to achieve for our clients is a dismissal. But the frustrating thing you should also prepare yourself for as employers is even if you receive that dismissal, it's not a vindication. What you receive is a letter that in a nutshell says, we are closing our file because the conditions that existed either have been corrected or no longer exist. They will never come out and say that the conditions never existed in the first place, or that you took all appropriate action or anything like that. So just prepare yourself for that. Another reason why you need to prepare a detailed response is that the employee who receives a copy of that dismissal may take it to mean that there was a problem and that you corrected it, and may go to a lawyer to try and seek some additional help. And it would be good that you would have a very detailed response to OSHA in your back pocket to share with opposing counsel when and if the time came. A client had also texted me earlier a question about what the North Carolina Department of Labor refers to as their consultative services division. And this is something I wanted to talk with y'all about for just a few minutes. The consultative services division is a free service to employers in North Carolina where OSHA will come in and evaluate your safety and health programs, evaluate how you are dealing with everything during this pandemic, and it gives you a safe harbor, namely meaning that if they find something wrong, if consultative services find something wrong while they're on your job site, you cannot be cited for it. So do I think it's a good idea to call them in now? I still, even though they won't cite you for it, they certainly won't come in and inspect your job site if you have a pending complaint. But if you do need help with those kind of issues, I do think they're a good resource. We've had clients use them with great success. And the other positive to that is that if they come in and let's say they provide suggestions which you correct, and later OSHA comes out, the investigative arm, and cites you for something that consultative services didn't catch or did not tell you to correct, you have a fairly strong argument that the OSHA citation should be abated. So those are the main points I wanted to make. So again, just in a nutshell, when you receive these complaint letters, do respond to them quickly. I would pick up the phone and call and let them know you have received it. That also, we had a client that we did that for, and we caught the OSHA administrator right as he was getting ready to leave to go to our place of employment. And because we called him, he was willing to wait and receive our written response. Ultimately, we received a dismissal, and OSHA never set foot on our property. So another reason to take that kind of action. And then I do recommend calling consultative services. It's a free service you already pay for indirectly, and gives you a safe harbor and can provide some real thorough, helpful advice. With that being said, I now want to turn things over to Emily Massey, my law partner and friend, who's going to speak with you about teleworking.
Okay, sorry, technical difficulties. Thank you all for being here and for spending your lunch hour with us today. I am going to talk about teleworking and employees who hesitate returning to work. Those are two of the most frequent questions that we have had throughout the pandemic. And there has been some recent guidance that has come out. So that's what I'm going to focus on today and hope that it's useful to you. So one of the key issues with teleworking is tracking hours worked and potential overtime. So for those of you who have non-exempt employees, and even if you may not be treating all of your employees as non-exempt, it's important to ensure you've classified them correctly. It's important that while they are working remotely, that they are accurately recording their time so that you can pay them for overtime. And on August 24th, the U.S. Department of Labor issued Field Assistance Bulletin 2020-5 regarding employers' obligations to exercise reasonable diligence in tracking teleworking employees' hours of work. You can find this bulletin on the USDOL website. So they are specifically addressing this issue. And the baseline requirement is that if the employer knows or has reason to believe that work is being performed, the time must be counted as time worked. Now, with teleworking and with lots of the workforce now being remote, how do you have such knowledge and how do you have reason to believe when an employee is working and potentially getting up to overtime? And that's exactly what the guidance addresses. And luckily, the DOL takes a very straightforward approach that employers can follow. First, have a policy that prohibits non-exempt employees from working unscheduled hours without written permission from their immediate supervisor, manager, or HR. You may already have that policy in place, but it's specifically very important when teleworking. Also, create a reasonable, easy to use process for employees to report all of their work time, including anything that's unscheduled or off the clock, as we typically say. The bulletin specifically states that an employee failing to report unscheduled hours through the reasonable procedures that you, the employer, has set up, means that you don't have to take any additional steps to try to uncover what work that they've been doing. If you have a reasonable process in place for them to go ahead and report those unscheduled or off the clock hours, if they fail to follow that procedure, you're not required to undergo impractical efforts to investigate and uncover those unreported hours or pay for those hours. Next, as you already know, unfortunately, you are required to pay them for any unscheduled or off-the-clock hours, but just remember that and make sure that your non-exempt employees and managers are aware of this policy, that you do have this overtime policy, that you have these methods for them to accurately record all of their times, and make sure you discipline employees who violate the policy. And it may be that your process in doing that it's not formal discipline. At first, it's a conversation, and then it moves into to more of a disciplinary process. But if you don't stop the misconduct, then it will keep occurring. So this naturally leads into talking about teleworking policies. We've had a lot of questions about what should a teleworking or remote policy look like. And really that depends on your business and your organization. And but there are a few points that I wanted to point out that you should make sure in there, especially if it looks like you're not going to be bringing folks back into the workplace, or if you want to integrate teleworking more permanently into your organization. First of all, from what we just talked about, make sure your policy states that all timekeeping policies, all meal and rest break policies, and all of your overtime policies still apply to remote working. Second, state that remote employees should have a designated home workspace that is maintained and kept free of safety hazards. We haven't seen these issues come up widely yet, but workers' compensation may apply to accidents that happen during working hours. So that's important to include in your policy, that the employee has to have a safe workspace. Refer to your company's information systems policy or acceptable use policy regarding company property. So laptops, iPads, your servers. Specify that company property cannot be used by anyone else that is not employed by your organization, and that all such equipment and information needs to be kept secure. Just reminding employees not to just leave their laptop and devices around for family members or anyone who's coming over that they can see sensitive information. And then again, it's just important to remind employees that hopefully these policies already state this, that they have no expectation of privacy over the company's information systems. And even though they're working from home, if they're using your information systems, they don't have an expectation of privacy over information communicated in that way. Emphasize that all duties and performance expectations remain in place. Just because you're working from home or remotely working, it doesn't mean that your job duties have changed. However, encourage communication with supervisors to determine if working hours should change or shift due to surrounding circumstances, such as virtual learning for children. And then finally, you may want to include what expenses, if any, the company will reimburse for remote working. In North Carolina, there is not a requirement for reimbursement of expenses, but I know that several companies do provide for that. And it is a best practice to have some of that in your expense reimbursement policy in writing. However, do know that there are other states that do require reimbursement of reasonable business expenses, the states such as California and Illinois. So make sure to check that if you have employees in those states. So when talking about the teleworking policy, I mentioned the topic I want to move to next, which is childcare issues that have arisen during the pandemic. We've received several questions from employers about how do we address employee performance and address employees balancing teleworking with virtual at-home schooling and daycare closures. Again, in your teleworking policy, emphasize that remote working does not change the employee's job duties unless otherwise specified by their manager. However, we are encouraging employers to communicate and be open with their employees about this issue, whether it's in your remote working policy, your pandemic, your temporary COVID-19 policy, or just a general communication from management saying that we will work with you. If you have virtual learning going on, or if your childcare provider is temporarily closed due to the pandemic, these are unprecedented times, and having flexibility in expressing understanding is good for employee retention and for employee performance. So that's what we're encouraging on that side. But keep in mind that if you have fewer than 500 employees, then your employees do have the right to invoke the FFCRA, which can provide up to 10 or 12 weeks of paid leave if the child care is not available due to the pandemic and the employee is the only responsible adult available to care for or supervise the child. So just be aware, that if you have not seen those requests yet, that you may be seeing them, especially since the FFCRA leave is due to expire December 31st. Now, there may be legislation that comes out later to extend that, but we're not aware of that yet. So the last issue I want to address is employees who are scared to come back to work. The initial response the employer should give is to ask the employee why. Why are you, we're transitioning back, into the workplace, what are your hesitations? And listen and be receptive to what they have to say. Hopefully this will help identify what their concerns are and you can quickly address them. As Will mentioned, you give a comprehensive overview of all of the protocols that you are taking. Now, this also, in this response, the employee may identify that they have some type of medical condition or disability, and this should automatically trigger you engaging in an interactive process with the employee as you would with any other employee with a disability. And this issue, however, what I really want to focus on is that it has recently come up in regard to employers who were allowing employees to work remotely during a specific phase of the pandemic, and now they are requiring employees to come back into the workplace. If an employee insists on teleworking when you have required them to come back, what do you do? Especially in the instance where the employee says, I have a disability, I have a medical condition, I'm going to stay home and keep teleworking. Well, on September 8th, the EEOC updated its guidance regarding disability accommodation and addressed this very specific issue. I mean, you can find their comprehensive Q&A on the pandemic, and you can see on their guidance, they include the date on which they've updated it. And so on 9/8/20, they updated their guidance. And so the EEOC explicitly states that the employer is not necessarily required to allow an employee with a disability to continue teleworking just because they were allowed or required to do so during the pandemic. According to the EEOC, the employee must show that they have a disability-related limitation that requires teleworking in order to qualify for an accommodation under the Americans with Disabilities Act. The fact that an employer temporarily allowed telework for the purpose of protecting workers from COVID-19 does not mean that the employer permanently changed a job's essential functions or that telework is always a reasonable or feasible accommodation. However, the EEOC stated that temporary telework arrangements during the pandemic could affect an employer's analysis of whether remote work is a reasonable accommodation. In other words, if previously you had indicated that teleworking is an unreasonable accommodation for a certain employee, but it was then became a reasonable or was possible during the pandemic, that analysis may now change. So I encourage you to look at those Q&A on the EEOC's website. I thought it was very helpful, and there's lots of tools out there for you, and we're always here to answer questions, and I'll be happy to answer questions during the roundtable. With that, I will now turn it over to my friend and colleague, Haley Wells.
Thank you, Emily. I would say if there's one topic that I'm asked about more than these telework issues, it is what happens when we have an employee in our organization test positive for COVID. This may be an issue that you have already grappled with. If not, I think it's one that you need to be prepared for so that you're not left scrambling in what may feel like a very urgent situation. So, to start kind of at the basic level, I'm sure many of you either have been and are continuing to conduct temperature checks in your workplace. If you have an employee who comes in and they exceed your temperature threshold and or they become ill after they arrive at work or start exhibiting COVID symptoms, then you want to immediately send that employee home and remove them from the workplace, other employees, and customers. You also want to make sure that you've clearly communicated to your workforce that if they are sick, then they need to stay home and stay in contact with their supervisors. then the question becomes, well, how long do sick employees need to stay out of the workplace? And for this answer, I'm going to go through the current CDC guidance, and that really needs to be what guides you in this analysis. And while the information that I'm going to provide to you is current as of today, you do need to be aware that the CDC does periodically update their guidance on how long sick individuals need to home isolate. And so if it is 2, 3, 4 weeks down the road, when you're confronted with this issue, make sure you go and check with the CDC under their Q&A about how long your employees need to home isolate, or you can confer with us to make sure that what you're requiring is accurate at that time. Under the current guidelines, an employee who has tested positive for COVID should stay home for at least 10 days since symptom onset, and at least 24 hours have passed since the resolution of fever without the use of fever-reducing medicine, and their other symptoms have improved from when they initially began experiencing those symptoms. A question that often arises in connection with a positive COVID test in your workplace is, do we have to close our business? And the answer to that is generally no, but you do need to do some of the following things in light of the positive test. The first is you need to close off any areas where the infected individual had some prolonged use of the space. So whether that be an office, it could be, if you have a restaurant, it could be a particular area of the restaurant. If it is someone who's working in a shared workspace, then you would want to close off that entire shared workspace. Additionally, you're going to need to engage in some additional cleaning of that area. What the CDC is currently recommending is that, if practical, that you open any external windows and doors to allow the area to air out and to increase airflow before the cleaning is performed. If practical, you want to allow at least 24 hours to pass before the area is cleaned. That will protect the individuals who are having to clean that area. If you can't wait 24 hours, try to wait as long as feasible before you actually clean the area. The reason that's recommended is because the virus can live on surfaces for hours, if not days. It can also stay in the room air. It can be suspended in the air. And so it is recommended that you increase airflow and try not to have a large number of individuals in that area. In addition to that more intense cleaning, you also want to make sure that you are regularly cleaning high-touch surfaces such as doorknobs, time clocks, any sort of keyboards that are shared by employees, restrooms, things of that nature. If you're unsure about what you need to be using and what strength chemicals, the CDC also has some great guidance on what you need to be using for when you're doing the cleaning of these surfaces. The next question that comes up after we have kind of gotten through the urgent situation of what do we do when someone shows up sick at the workplace is, what about our other employees? Do we have a duty to tell them? What can we tell them? What should we not tell them? The first thing that you should consider when you know that someone has been in your workplace and that they have been infected with the virus is, who have they had close contact with? The CDC defines close contact as being within less than 6 feet for more than 15 minutes of someone. So if you know that there are individuals who've had close contact with the individual who now has COVID, then you need to tell those individuals that they've possibly been exposed to the virus. If you take away nothing else from this presentation, please know that unless the infected individual gives you permission to publish their name, you should not tell the other employees who it is that you have learned has COVID. Now, we often get some pushback from clients on that, and they'll say, well, now look, Sam is the only individual who's going to be absent from work for the next 2 weeks, so everyone is going to know that it is Sam that we're talking about when we say that someone in the workplace has been exposed to COVID and is now at home. And that's fine. It's fine that employees are able to figure it out through their own investigation. But what is important is that you as the employer, not publish the name of that individual and publish the fact that they've had this diagnosis unless the individual tells you that they're okay with you sharing that information. In many instances, the employee will. The employee can also be a good source of information for helping you figure out who they may have had close contact with. If you're not able to gather that information, then you'll want to go through the workflow and make sure you understand who that employee is interacting with, so that you can identify the employees who you need to put on notice that they may have been exposed. If you have an employee who has a positive COVID test, then they need to be excluded from the workplace and remain in home isolation pursuant to those CDC guidelines. That is for at least 10 days from the date of either symptom onset or the positive COVID test, at least 24 hours since the resolution of fever without fever-reducing medicine, and all other symptoms have improved. Now, you're going to have other employees potentially who may have been exposed, but who are exhibiting no symptoms. They do not have a positive COVID diagnosis. How long do they need to stay away? For employees who fall into that category, that is a potential exposure to someone who is known to have COVID, but who have no symptoms and who have not been tested, they are currently recommended to home isolate for 14 days. Now, if they then, let's say on day 2, start to come down with symptoms, they fall under that 3-tier analysis, which is they need to home isolate for 10 days since symptom onset, at least 24 hours have passed with no fever, without the use of fever-reducing medicines, and other symptoms have improved. So there can be a little bit of inconsistency there, which I think sometimes leads to some frustration, but do be aware of the divergent guidance or the conflicting guidance that's currently out there. For employees or individuals who've been potentially exposed, they should home isolate for 14 days unless they start to come down with symptoms or unless they get a positive COVID test. Then they move under that second set of criteria, which is a 3-part analysis. If you have employees who go and they get a COVID test, but and the test is positive, but they have no symptoms, then they also fall under that guidance of home isolating for 10 days as opposed to the 14-day period. All other employees in the workplace who were not in close physical proximity, that is less than 6 feet for more than 15 minutes with the impacted individual, they should continue to monitor themselves for symptoms. They may come to work. It's recommended that they use face coverings if that's not something that you currently require in your workplace. Then they should be doing that until they are past that potential incubation period. The final question that kind of comes up, I would say, with some frequency is, what do we do if Jane has not worked for, let's say, 6 days, and then we find out that she's tested positive for COVID? In that instance, there are 2 different ways you can approach that. If it's been less than 7 days since the employee used your facility, then you need to follow the CDC's guidelines on cleaning and disinfecting that apply to a sick individual being in your premises. If it's been more than 7 days, then there are no heightened cleaning requirements for your facility, because it's believed that the virus cannot survive on solid surfaces for more than 7 days. Generally, the CDC recommends that an employer not require that an employee bring forth any sort of negative COVID test or documentation of that nature before they're allowed to return back to work. The time guideline and symptom resolution guidance that the CDC has issued is what should guide you on whether or not you should allow the employee back into the workplace, because an individual may test positive for COVID for a period much longer than the period during which they could actively shed the virus and infect other individuals. Finally, be aware that if an employee is awaiting their COVID test results, or if they've been ordered to quarantine, then they are, and you're an employer with less than 500 employees, then the employee could very well be eligible for paid sick leave under the FFCRA. And Grant's going to talk a little bit about some of the employers who may fall out of that requirement because of the nature of their business. And if you're in the lucky position of having not had to confront this yet, then I think the thing that you should focus on right now is to document your process. That is, what do we do if we find out that someone has been infected with COVID? Kind of, what's our process map to get through that? You also want to make sure that you've clearly communicated to employees the fact that if they're experiencing any symptoms, then they should stay home. They should stay in touch with their supervisors and notify your supervisors and train them on what to do if they become aware of a sick employee in the workplace. At this time, I'd like to turn it over to my law partner, Grant Osborne, who is going to talk with us about recent court decisions that will impact some of the COVID-19 regulations.
Thank you, Haley. Good afternoon, everyone. By now, you must be feeling that you're drinking from a fire hose. There's so much law and so many practical implications to consider in the context of the FFCRA. The portion of this presentation on which I'm speaking to you today deals with a recent change to some regulations as they apply to healthcare providers. Essentially, everything you've heard so far, I think it's fair to say applies to about all employers that are covered by the FFCRA. What I'm going to say today applies to healthcare providers. You may see on the PowerPoint slide that says update on court decisions. That tells you how quickly the law is changing these days. When we first began to plan this presentation, I planned to speak with you primarily about the effect of a federal court decision in New York issued just last month in early August. But since that time, one of the federal regulations issued pursuant to the FFCRA has been substantially amended. So again, to be clear, what I'm addressing today is not the statute itself, not the FFCRA and the parts that apply to employers. One has to have a tolerance for long names and acronyms, the Emergency Family and Medical Leave Expansion Acts and the Emergency Paid Sick Leave Act that apply to, as we know, employers, essentially all employers with fewer than 500 employees. But I'm going to speak rather about some regulations that were issued just recently and then in fact took effect as of yesterday. Both the Emergency Family Medical Leave Expansion Act and the Emergency Paid Sick Leave Act have a provision that says, and here I can essentially quote, that an employer of an employee who is a healthcare provider or an emergency responder may elect to exclude the employee from the application of those provisions. Well, on April 6th, the DOL issued a regulation construing the statute, and that's typically how it works. Congress enacts a law, the law is passed, and then it's up to an executive agency to issue regulations to tell employers and those affected by the law how the law may work in practice. So on April 6th, the Wage and Hour Division of the US DOL issued many regulations, very detailed, including a definition defining what a healthcare provider is. The broad definition adopted by the DOL in April of this year surprised many of us because of the breadth of the definition. Essentially, as I've told people, the definition was so broad that if you're a healthcare provider, rather than healthcare business, and you had an employee who of any kind who got a W-2, an employer could take the position that those people, all employees, were healthcare providers. That broad definition, which of course would permit anybody in the healthcare business to exclude all its employees from the paid leave provisions of the EPSLA and the Expanded Family Medical Leave Act, those provisions were challenged by a lawsuit filed by the state of New York. And as a result of that decision, which came out, I think on August of this year, in state of New York versus the Department of Labor, pardon me, the court held that the Department of Labor had exceeded its authority quite a bit by promulgating such a broad definition of healthcare provider. Part of what the court said is actually kind of amusing. The judge who wrote the opinion said that under the DOL's definition, an English professor at a university with a medical school would be a healthcare provider, and that professor would be surprised to find that as far as the DOL is concerned, she is essential to the country's public health response. That decision was surprising in the sense that it was issued so quickly, but to many of us, not terribly surprising. Occasionally, the DOL's regulations are overruled by a court. And in this case, the court said that regulation is simply too broad and it cannot be allowed to remain. So again, that was on August 3. Well, just this month, the DOL responded on September 11 with an update to its very substantial FAQs that are on the DOL's website. I think you can see now before you question 56, in which the DOL asked the question rhetorically, who is a healthcare provider who may be excluded by the employer from paid sick leave or the expanded family medical leave? I will not read the answer to you. You can see it there on the PowerPoint, which of course I believe we can provide to all of you at the end of this presentation. But the bottom line now is that before this DO regulation came out again yesterday, a healthcare provider whom an employer could exclude from all the paid leave benefits of the FFCRA was essentially any employee of the healthcare provider, meaning the employer in the healthcare business. The scope of those who may be excluded from those paid leave benefits has now been narrowed very substantially. And to summarize it, a healthcare provider, that's an employee who may be excluded from the paid leave benefits of the FFCRA, is a licensed doctor of medicine or nurse practitioner or other healthcare provider who's permitted to issue a certain kind of certification under the FMLA. And here, if I may, I'm going to look to my right and actually look at the regulation, which says that a healthcare provider is somebody defined in, goodness, yet another regulation, which is essentially a doctor of medicine or osteopathy who's authorized to practice medicine or surgery. Or it's any other employee who's capable of providing healthcare services, meaning that he or she, and this is actually worth reading with care, so I'll read this to you. It's any employee who is capable of providing healthcare services, meaning that he or she is employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care. And this is a key point, and if not provided, would adversely impact patient care. So it's fair to say that if you have an employee whose services, if they were not provided, would adversely impact patient care, that's a healthcare provider. So there is room for interpretation here, as you can see. The regulation that came out again yesterday, and I can give you the citation for those who are taking notes. It's 29 Code of Federal Regulations at CFR, 29 CFR, section 826.30, and you can find that very easily. And the regulation says explicitly that employees of the kind that I just mentioned, those who are able to provide healthcare services, include nurses, nurse assistants, medical technicians, and other persons who directly provide medical services to patients. The regulation, and this is very helpful, it does point out that employees who do not provide healthcare services are not healthcare providers, such as IT professionals, building maintenance staff, HR personnel, cooks, food service workers, records managers, consultants, and billers. So the regulation is very helpful in that it does give some explicit examples of those who are not healthcare providers as far as this exclusion from the FFCRA is concerned. Again, this regulation took effect as of yesterday. It will remain in effect until the end of the year. As my colleague Emily mentioned, it's possible that further legislation may come down the pike. I think, I can't speak for everybody, but I believe it's fair to say we will not be shocked if the FFCRA is extended to last beyond the end of this year, and that the regulations that I've been through will continue in some form as well. I'll talk later, I believe, about one of the questions that's been put to us about the impact of the FFCRA and personnel policies. It's fair to say that the FFCRA is very complex. It's confusing even to those of us who live in this world, much less to employees who don't know much about it. But the takeaway I would offer to all of you who are involved in healthcare is that the definition of a healthcare provider has been substantially changed. And for those who took the position before yesterday that its employees, all of its employees could be excluded from the paid leave provisions of the Act, need to revisit that decision, because those who can be excluded have been substantially narrowed from what they were before. I realize I've covered an awful lot, but with an eye on the clock and knowing that I have other colleagues who wish to speak with you as well, I'll now introduce my colleague Xavier Lightfoot, who is going to speak with us about the critical subject of unemployment compensation.
Thank you, Grant. Hello, everyone. Thanks again for being with us today. I am going to briefly discuss some of the background to the current unemployment landscape and provide a summary on where we currently stand in this area. So during the height of the pandemic in about mid-March and early April, we fielded many questions from employers who had to furlough or lay off employees. Many of those employers were rightfully concerned for the livelihood of their workforces. They wanted to know about the unemployment insurance benefits available to those workers. So initially, our conversations with clients were focused on eligibility requirements, the impact to employers' accounts from employees receiving certain unemployment benefits, and the calculations used to determine what an employee's weekly benefit would be. Those conversations developed even more once Congress passed the CARES Act, because that piece of legislation provided for several additional unemployment programs, which expanded unemployment benefits and also increased the population of individuals who could receive such benefits. For example, the Federal Pandemic Unemployment Compensation Program, which is otherwise known as FPUC, provided for a short-term benefit in the form of an additional $600 in weekly benefits to eligible claimants. But at this time, that is no longer the case because the FPUC benefit expired at the end of July. So the question becomes now, where are we currently in this area? Well, unlike the spike that we saw in jobless claims at the height of the pandemic, new unemployment claims remain unchanged week over week as of September 5th. This is some indication that the nation is making progress towards getting individuals back to work. But we still have a ways to go because as of last week, there were still 13.6 million Americans unemployed due to the pandemic. In an effort to provide some additional relief to this population, President Trump issued the memorandum on authorizing the Other Needs Assistance Program for major disaster declarations related to coronavirus disease 2019. That was issued on August 8th, and it is effectively an executive order that was designed to provide additional benefits to that unemployed population. In that memorandum, the president directed $44 billion from the Department of Homeland Security's Disaster Relief Fund to be made available for lost wages assistance to eligible claimants. And that was for individuals, well, in order for individuals to receive those funds, governors of each state had to make a request to the FEMA administrator for lost wages assistance. And they also had to agree to administer delivery and provide oversight for the program. So initially, states had concerns regarding how the lost wage assistance program was going to be administered. Last month, the DOL published some guidance, some operating guidance 4 states who were going to be requesting grants to that LWA funding. North Carolina made its request last month and was approved for funding on August 21st. As of September 3rd, the Division of Employment Security, also known as DES here in North Carolina, they began issuing LWA payments to eligible North Carolinians. So the LWA program, it includes a $300 supplemental payment in unemployment benefits for North Carolinians who have an unemployment benefit amount of at least $100 a week and are also out of work due to COVID-19. LWA is available for 6 benefit weeks starting on August 1st and ending September 5th. So a claimant could apply and if he or she is deemed unemployed due to COVID-19, would be eligible for retroactive payments. FEMA, however, has notified states that funding for the LWA program, it is not going to be provided for any additional weeks. So with many North Carolina businesses having reopened or planning to reopen soon, our conversations have shifted with our clients, and we have fielded some inquiries regarding what should employers do if they potentially want to challenge or contest an unemployment determination. And so what we've seen is that there's been so much volume that DES has fielded on their website and at their call centers in regards to unemployment claims, that when an employer is in the position of getting ready to contest or challenge a particular determination and file their notice of appeal, they are not receiving a response to that filing. And so DES on their website, they advise that the best and fastest way to file an appeal is by using their online system. However, with the increased volume, what we encourage all employers to do if you're in a situation where you're going to be filing an appeal is you want to consider doing that from multiple standpoints. So in order to preserve your right to appeal, we encourage you to, 1, file the appeal online. 2, you want to send it via mail and also email to DES. And 3, you want to follow up with DES by calling them and confirming that they actually received the appeal well in advance of that deadline. And those are the things that you're going to want to do in order to make sure that that appeal is filed in a timely fashion and that you're preserving your rights to actually challenge and contest any unemployment determinations. At this time, I'm going to turn it over to my good friend and my colleague, Justin Hill.
Good afternoon, everybody. I'm going to take some time to go through some of the pre-submitted questions that we had, and then after that, I will turn it over to Ken to take some of the questions that we've received throughout this presentation. Grant, you alluded to it earlier, so I'm going to start with the first question to you. The first question is, should employee handbooks be updated to reflect COVID-19 time off policies?
Yes, thank you very much. I'll try to be brief, which I'll admit is difficult, especially when given a subject of this complexity. The short answer is yes. I guess the underlying answer would be the FFCRA itself does not require that employers provide information in personnel manuals or personnel policies about the FFCRA and the leave benefits. But the Act and the regulations do say that certain kinds of notification have got to be provided, typically in the form of a poster. Again, for those who are taking notes, I'd refer you to 29 CFR, section 826.80, called employer notice. There are some requirements there about what employers have to say. But if the question is, should handbooks be updated? I would say yes, especially if the manual, pardon me, includes information about PTO policies, such as the accrual and use of PTO or payment in lieu of PTO, you certainly want to consider addressing your position about the FFCRA and whether you're subject to it and what benefits may be available, for the very simple reason, at least, of avoiding inconsistency with the Act, especially employers who are covered by the FMLA, the Family Medical Leave Act, which typically applies to employers, as you know, of 50 or more. You've already got a policy about leave. So it's appropriate to update your policy to address your obligations, if any, as regards the FFCRA. And finally, so as not to take too much time, I hope, for those who are in the business of healthcare, as you've heard me say, you have the option of excluding healthcare providers from the paid leave benefits. The Act does not require that employers do that, but does give employers that option. But if the employer has not affirmatively excluded healthcare providers from those benefits, then arguably the employer remains subject to all the requirements of the FFCRA. So the personnel manual would be a great place in which the employer should state its position regarding the eligibility of healthcare providers for paid leave benefits under the FFCRA. That's my short answer.
And thank you for that, Grant. The next question will go to Xavier. That question is, as an employer, how do we respond to employees who were initially furloughed due to COVID-19, but have been recalled to work and have resisted or refused?
Thank you, Justin. This is a great question because one of the things we saw initially as businesses began to reopen and recall workers back to the workforce, some previously furloughed employees refused or resisted the employer's recall to work. That was the case because due to the federal pandemic unemployment compensation, the FPUC, some folks were making more on unemployment than what they would have earned if they returned to work. Now that FPUC has expired, we do not see this situation as much. However, there are still some situations where employees are refusing or resisting the recall to work. In those situations, as my law partner Emily discussed earlier, employers will first want to engage with the employee and to determine exactly why the employee is refusing or resisting the return to work. So long as the employee does not raise any OSHA or teleworking/disability related concerns, then you'll want to take the approach of educating the employee on unemployment fraud. In doing this, there's 4 steps the employer should take. First, you want to confirm the individual's refusal to return in writing. Second, what you want to do is inform the individual in writing of the consequences of unemployment fraud. The third thing that you want to do is inform the individual that you as the employer are going to report their availability for work and their refusal to return to work to the unemployment office. The last thing you want to do is treat the employee's refusal to return as a voluntary resignation and terminate the employment relationship, assuming the employee was furloughed or they had their hours reduced.
And thank you for that answer, Xavier. This next question seems like it is most encompassed in what you spoke about, Emily. So I'm going to direct that one to you. If we have to close our office again, how do we handle an employee that says working remotely causes mental health issues?
Thanks, Justin. Yeah, I saw that question submitted, and it's really interesting because the majority of the situations we have seen is an employee who wants to remain teleworking, like what I spoke about in my brief presentation. I personally have not encountered this issue before where someone wants to come into the office. And so I think it really depends on what stage are you in as a company. If you are having some, if your office is open, then we're looking at the reasonable accommodation analysis and the interactive process under the ADA. I would think it would likely be a reasonable accommodation to allow them to come into the office if you have other folks there. However, if your office is closed due to the pandemic and that is part of your COVID-19 plan, I think that changes the analysis, and it would be very difficult. To me, it seems like it may not be a reasonable accommodation just to have one person coming in. So it very much depends on your organization. But again, applying the same analysis that you would for any other type of disability and whether or not it's a reasonable accommodation.
And thank you, Emily. The next question I'll direct to Ken. That question is, can COVID-19 sick payments be deducted from 943 returns?
Yes. It actually, it would depend if you are an agricultural employer. Well, let's get the language exactly right. Actually, the benefits that are paid under the FFCRA are tax. You can take a tax credit for that. So it's not a deduction, it's actually a tax credit. And you can do so for most employers on your Form 941, which is your quarterly tax return form. If you pay agricultural workers, then you can use a quarterly tax return form 943, or you could take the tax credit on your annual federal tax return, which is a form 944.
And thank you there, Ken. Our next question is, how do we handle disciplining employees for a legitimate reason when the employee has recently filed an OSHA complaint? And Will, if you could handle this one for us.
Sure, happy to. Thanks, Justin. Very carefully. So most of us are familiar with the Retaliatory Employment Discrimination Act in North Carolina. It's the law that provides that employers cannot discriminate against employees for doing things that by law they're protected to do. So the classic examples are filing or otherwise threatening to file a workers' comp claim, or filing an OSHA complaint. And so certainly we have to hold the employees who do have such concerns with OSHA to the same standards that we hold their coworkers, but we have to be very careful about the way we discipline them. Because if we give them a toehold to claim that we are retaliating against them in either demoting them, terminating them, or otherwise disciplining them, they can file a North Carolina Department of Labor Retaliatory Employment Discrimination Bureau complaint within 180 days of the last date of purported retaliation. And then even if the North Carolina Department of Labor ultimately determines that no retaliation occurred, they still have 90 days to file a lawsuit. And plaintiffs' attorneys love these lawsuits because it's one of the few laws in North Carolina that allows for the recovery of not only trouble damages, but also attorney's fees. So in a nutshell, back to basics here, document. If you think you've got enough documentation and enough issues to terminate the individual that you believe may have filed an OSHA complaint, my advice is likely going to be, if you call me, wait a couple more times. Overdo it, stretch it out, so that there's not the temporal proximity between the filing of the OSHA complaint and the adverse employment action.
Thank you there, Will. This next question I'll ask to Haley. Am I required to conduct contact tracing if an employee tests positive for COVID-19?
Generally, no. If an employee tests positive for COVID, then the lab that performs that test is going to report it to the local health department, and the local health department will conduct any contact tracing into the community that it feels is required. However, as I discussed during the presentation, you do want to notify any of your employees in the workplace that they may have been exposed to someone who has tested positive for COVID, and try to work with the infected individual to determine who they may have been in close proximity with, so that you can make sure that those employees have been notified.
Thank you, Haley. And this last pre-submitted question that I have, I will direct to Tom. The question is, what is the cap on employee compensation and how does that work?
Yeah, the cap on employee compensation is part of the Paycheck Protection Program. And it falls under the definition of payroll costs. As you're completing your forgiveness application, don't forget that there's a set of rules that define each of the costs that you could use the loan for. So for example, payroll costs has a specific definition, and you can only use PPP funds for those payroll costs. As part of that definition, there's a cap on cash compensation to employees. So if you're going to use a 24-week covered period, the cap per employee in their cash compensation is approximately $46,000. So part of your documentation requirements is to have per employee level detail of how you use the loan. So just keep in mind as you're filling out the application that there's a cap on employee compensation. You can't use the PPP loan to pay employees in excess of the cap. But generally it's $46,000 approximately per employee. And then there's a different set of rules for owner employees. So as you go through that forgiveness application, keep the cap in mind and apply the rules as you run the calculations for your application.
And at this time, I'll turn it over to Ken for some of the live questions that we've received.
Okay, so we'll look at some of the live questions that have come in, and I'll direct this one to Emily to start off with. And it's about paid sick leave or paid FMLA under FFCRA. If my employee's spouse has PTO and can take it, can use it to take care of their child, can the employee still invoke FFCRA as an option so that she could be out as well?
So this is tricky. Really what the requirement is that the employee certify to you, the employer, that there is no, and I just pulled up the guidance to make sure I had the language correct, that there's no other suitable person available to care for the child. They have to, and part of the documentation they are required to submit to you is stating the name of the child being cared for, the name of the school, place of care that has been closed or unavailable, and then a statement from the employee that no other suitable person is available to care for the child. If the person, if the spouse could take PTO or does take PTO to take care of the child, I don't think they can honestly say that. Could they say that the PTO is being saved for the holidays, and so therefore there is no suitable person? They could also say that and provide the honest statement. So unfortunately, I don't think we're in the place to make that judgment. And if the employee applies, our recommendation generally is if they apply for it and they provide documentation and certify this information to you, and you don't have a reason to believe that it's absolutely false, then you need to grant the leave to the employee. And I welcome my colleagues to disagree with me.
I think that sounds very accurate. Let's go to the next question, and I'll point this one to Haley. What about an employee with symptoms but a negative test?
So in that instance, the CDC recommends that the employee be treated as someone who has a positive and is also symptomatic. So you're going to apply that three-part analysis. That is, the individual should they should home isolate until the resolution of symptoms, 10 days after the onset of symptoms, 24 hours without the use of fever-reducing medicines, and until the symptoms have generally improved.
Okay. Anyone else wants to add anything to that? All right. Let's see. Emily, or anyone else, is there a range or average that employers reimburse for business expenses while working from home?
No, and I think really it depends on what your practices are. So for example, if you do not already have a cell phone reimbursement policy, it might be something you want to think about. Employees might be concerned about how much they're using their cell phone. But again, in North Carolina, it's not required that you reimburse that. And some employers have been providing equipment, or saying you can purchase X equipment, we'll reimburse you for it. So it's really up to your business if you want to say we'll give you this allowance The other implication, and I'm not the best person to advise on this right now, is whether under IRS, having an accountable plan about how the tax implications of how you want those expenses to be applied. I mean, that's something your accountant or one of our tax attorneys can help with if you have specific questions in that regard. But welcome my colleagues if they have practical experience of specific expense policies employers have used.
Yeah, well, I'll just chime in that, yeah, in North Carolina, there's no law that governs this other than if you had somebody that was close to minimum wage and they're incurring these expenses, it can't be attributed such that it actually would take them below minimum wage. And then also for any employer on the call that has operations in other states, you need to make sure that you know about what the deal is in those states, because there are some states that have mandatory reimbursement, business expense reimbursements. And for example, California is one, and it says that employers must reimburse all necessary and reasonable expenses incurred by employees in the direct consequence of discharging their duties or at the direction or request of their employer. And other states that have these type of laws, off the top of my head, I think Illinois does, Montana, New Hampshire, North Dakota, and I think South Dakota as well. So any operations in any of those states, there are specific business expense or job related expense laws on the books. So you'll need to make sure you're taking a look at those situations if you have employees that are working remotely in those states. Okay, the next question. If a doctor's note states the employee needs to be out for 19 plus days, but CDC says that once you're quarantined for a positive or negative test for 10 days, which do we follow? Who wants that one?
I'll be happy to answer that. I think you go with the doctor's note. Clearly there can be extenuating circumstances that may require the individual to be out for longer than what the CDC recommends. And so I would say go with that doctor's note.
Okay. Next question. How is FMLA and COVID FMLA different? And what documentation is needed? So who wants to jump on that one?
Can I make one observation, but I'll quickly lateral the ball to somebody else. The conspicuous difference is the fact that under the FMLA, assuming a covered employer and a covered employee, the leave of absence, or LOA, is not paid. Under the FFCRA, the leave will be paid. That was one of the radical effects of the FFCRA. This is the first nationwide paid leave law that we've ever had. So that's a huge difference. If somebody is not eligible for paid leave under the Paid Sick Leave Act or the expanded FMLA, then the only kind of leave you're talking about is unpaid leave. But if the employee is covered by one of those two paid leave components, then of course the employer could be looking at paid leave. And to dovetail with what Haley just said, this is not the time to be cavalier with these laws. The law never dictates fairness, but the law does prohibit discrimination and retaliation. And no employer wants to be in the position of having to later explain a decision that appeared to be discriminatory or retaliatory.
Right. And another difference would be under regular FMLA, an employee has to work for at least 12 months for that employer and must have worked 1,250 hours during that preceding 12-month period. And they must be within a 75-mile radius. There would have to be 50 employees in that radius that the employee works in. So that's the regular FMLA. Under the Families First FMLA, as you said, it's paid. It starts if somebody has been there for 30 days. So it's less, it's only 1 month as opposed to a whole year. And it applies if you're a company that has anywhere between 1 and 499 employees. And so, and it doesn't matter where they are. You could be the only employee in California or in North Carolina, and the rest of the company is in a different state, but you're covered by the CRA paid FMLA. And as far as the documentation goes, you don't have to have nearly the documentation that you typically do in regular FMLA cases, where you got all that documentation that the Department of Labor has given us to submit to the medical providers. Basically, we just have to have the documentation, and Emily spoke to it earlier in terms of establishing that you're entitled, to take the extra 10 weeks because you have a child that's either out of school or out of daycare due to COVID-19. And so you would just have to provide the documentation that Emily spoke about earlier that proves that that school or daycare is not operating in person or is open for these children to come in. That's going to go a long way towards that. Anybody else want to add in anything? Okay, next question. If an employee says they have been in close contact with someone who has tested positive, but the employee has no symptoms, should we tell them to go get tested, or should we tell them to work at home for 14 days? And if their test is negative, should they come back to work immediately?
So under the CDC's current guidance, that individual should home isolate for 14 days. If they become symptomatic, then they fall under the 3-part analysis where you're looking at, has it been 10 days since the onset of symptoms, at least 24 hours since the resolution of fever without fever-reducing medicine, and general improvement of symptoms. If they've been in close contact and remain asymptomatic, according to the CDC, they should continue to home isolate for the 14-day period, because despite the negative COVID test, they could still have the virus and be potentially exposing your other employees.
Okay. Anybody else got anything to add there? All right, the last question that has been submitted. Can an employee refuse to wear a mask by citing mental health issues? Who wants that one?
I'll dive in on that, although it's some risk to myself. So I would say generally, no. An employee cannot say, I find wearing a mask stressful. Many people may say that. An employee could say, I cannot wear a mask because I have a disability that makes it problematic for me to wear a mask. And then, as Emily was saying, that would implicate the whole interactive process between employer and employee to determine whether the employee, in fact, has a disability covered by the ADA of 1990, and whether a reasonable accommodation would include the non-wearing of a mask. I personally doubt that would ever be a reasonable accommodation in this day and time, but others may have other opinions. But the short answer is no.
Right, and then you certainly have to determine if this is something we do have to accommodate, i.e. not requiring that person to wear a mask. And if so, then what other options do we have? I mean, could we do a face shield, for example? And I'm starting to see more and more options there with shields that not only come down over the face, but some that come up. And a lot of teachers are using those because it allows them to be able to speak to their class, and people, particularly teachers that instruct on foreign languages, because the kids need to be able to see their lips moving. And so that's actually been a pretty effective option. And it could be that you have to, and it gets all into the accommodation issue where we may have to decide to modify the work area and put up some plexiglass, but ultimately it is probably unlikely the person is entitled to that accommodation. But if they can provide some documentation, like you said, Grant, then we would have to at least start the process. I do see that we've had one more question come in, and we'll tackle this one before calling it a day. Why not send an employee who was in close contact with someone who tested positive to get a COVID test? And if it's negative, why can't they return to work?
Well, according to the CDC, which is what we're basing our recommendations on, the individual who has been in close contact, if they went and immediately got a COVID test, they could very well get a negative COVID test. And then you would allow them to return to work. And then let's say 2 or 3 days later, after that negative COVID test, they're then in a position where they're able to shed the virus and infect other employees. I think that's why the CDC is recommending that someone who knows they've been in close contact with someone who is COVID positive, home isolate for the 14-day recommended period. It's only once they develop symptoms or get a positive COVID test that they then fall under that 3-part analysis, which could allow them to come out of that home isolation earlier.
Yeah, and I'll just add in, my daughter lives in a sorority house in Chapel Hill, and 6 of those girls got COVID, including my daughter. And her roommate tested and was negative, and then started coming down with symptoms several days later, and then was positive. So she had it, she just had not had enough of it to develop in her system yet, so that it would show as a positive test. And so that's exactly the reason that you don't want people immediately going and getting tested and if it's negative coming back to work, because they could actually have it and it just didn't quite show up yet. So that's exactly right. And by the way, everything's good. She's completely fine now, but it's easy to transmit, I will tell you that. And I think that is the conclusion to our question. So Jen, I'll turn it back over to you.
Great. Thank you so much, Ken. And thank you to all of our speakers today. For those in attendance, following the webinar, you will be sent an email with a list of articles related to the issues we discussed today and other helpful information. We also will make a recording of this webinar available. As a reminder, Warden Smith is recognized by SHRM to offer professional development credits, and this program is valid for 1.5 PDCs. It's also been pre-approved by HRCI for 1.5 hours. If you do need SHRM or HRCI credit, please email us at rsvp@wardensmith.com, and I'll send you a certificate of attendance and a copy of the webinar materials for submission. We so appreciate you taking the time to join us today and hope you're able to take some of the information you learned and apply it to your own business. Thank you again, and this concludes the webinar.